You've probably heard the rumors. Marriage green cards are getting a lot harder. Headlines warn about waivers under attack and a wealth test coming back. But no one's explaining what that actually means right now under Trump's second term. If you're married to a U.S. citizen or applying soon, the way the government looks at your history and money could seriously affect whether you get approved or stuck outside the country. Hi, I'm immigration attorney Zaira Solano, practicing immigration law for 14 years, and in this video, I break down what's really happening as of late 2025 going into 2026. What's really changed, what's being proposed, and what you can do right now to protect your green card. Let's get into what's actually changing for marriage green cards and how tightening around waivers and revival of a tougher wealth test could affect your path forward. We're now in President Trump's second term, and his administration has made immigration a top priority again, not just at the border, but in legal immigration as well, including marriage-based cases. First, waivers are under pressure. The laws allowing waivers for unlawful presence and certain misrepresentations still exist. And forms like I-601 and I-601A are still available, but processing is painfully slow. Scrutiny is higher, and there's active talk in Washington about tightening this relief even more. Second, the public charge wealth test is being revived in stages. At U.S. consulates abroad, new State Department guidance now tells officers to look very close at an applicant's health and finances when deciding if they might become a public charge. And DHS has already started the process to rewrite the public charge regulation for green cards inside the United States, which could bring back something similar to the tough 2019 wealth test we saw. Let's break this down, starting with waivers. A marriage-based waiver is a legal safety valve. If you're married to a U.S. citizen but have a problem in your immigration history, like staying in the United States without permission, a waiver can let you still qualify for a green card if you prove your U.S. citizen spouse would suffer extreme hardship without you. These waivers are most commonly used for someone that has been in the United States illegally for more than 6 months. That means that they trigger the 3 or 10-year unlawful presence bars, and this person entered the United States without a visa or has certain types of misrepresentation. Here's the key point for late 2025. The underlying waiver laws are still there, but the way those waivers are being processed is getting tougher. Forms like I-601A are still available, and USCIS released a new edition earlier this year, so waivers haven't been formally ended like many people think. But here's what has changed. Extreme delays mean that provisional unlawful presence waivers now roughly take 30 to 36 months to process and get a decision. Policy guidance issued in 2025 stresses that people who lose their status are more likely to be placed into removal proceedings, deportation proceedings. Lawyers are seeing more notices to appear after bad outcomes. And DHS has publicly said it's closing loopholes and restoring integrity to legal immigration, which means officers are being pushed to apply the law more strictly. So the fear that waivers could disappear entirely isn't coming out of nowhere. But as of right now, they still exist. The risk is that they are slower, harder, and more fragile than they were a few years ago. Let me tell you about a real-world example. Meet Maria, a U.S. citizen, and her husband, Jorge, from Honduras. Jorge crossed the border without a visa in 2012, and he never fixed his status to become legal. He's been working, paying taxes, and raising 2 U.S. citizen children with Maria. Today, Maria can still apply for Jorge's green card because Jorge will trigger a 10-year bar if he leaves the United States to attend a U.S. embassy interview. He will need a provisional unlawful presence waiver before his interview at the embassy. They will have to prove that Maria would suffer extreme hardship if he were stuck outside the United States for years, or if Maria and her kids had to pick up and move to Honduras for him to wait out the 10-year bar. Here's the difference in late 2025. The waiver could take 3 years or more just to be decided. While the case is pending, Policy changes make it more likely that any misstep could lead to removal proceedings. And if future regulations narrow these waivers, families like Maria and Jorge could lose this option entirely. The path hasn't slammed shut yet, but it's getting narrower and riskier. If you're already filed for a waiver, your case is still alive. There's no law that automatically cancels the I-601 or the I-601A waivers right now. Expect long waits in the 30 to 36-month range, sometimes even longer if USCIS issues a request for evidence or a notice of intent to deny. Scrutiny is higher, with more detailed questions about hardship, finances, and prior history. If you haven't started yet, waiting too long can be risky, not because waivers have disappeared, but because future rules could narrow who qualifies. What you do today can affect whether your family has options if the rules tighten up in 2026. Now let's talk about this wealth test, officially called the public charge rule. Public charge has been part of the United States immigration law for over 100 years. It's nothing new. It lets the government deny someone a visa or a green card if that person is likely to become primarily dependent on certain government benefits. Here's where things stand right now. Under Biden in 2022, DHS issued a fair and humane public charge rule that only counts certain cash assistance programs and long-term government-funded institutional care. That rule is still in effect today for green cards processed in the United States. But in 2025, Trump signed an executive order telling federal agencies to tighten eligibility checks. The State Department has now issued new guidance to consular officers abroad, telling them to consider health conditions like diabetes, obesity, cancer, and mental health issues, along with a person's long-term ability to pay for care. And DHS has sent a new public charge regulation to the Office of Management and Budget, the first step in rewriting the rule for adjustment of status cases inside the United States. So, is this wealth test actually back? For people applying at consulates abroad, a tougher health and wealth-focused public charge analysis is already here. For people adjusting status inside the United States, the older Biden-era rule is still in effect right now. But DHS has clearly started moving towards something stricter. If you're applying for a marriage green card, there are now two layers to think about. First, the affidavit of support, Form I-864. Your U.S. citizen spouse must prove enough income, usually at least 125% of the federal poverty guidelines, and sign a contract promising to support you. That has not gone away. Second, the border public charge analysis. Inside the United States, USCIS still uses the 2022 rule looking at household income and certain cash benefits. But at a U.S. consulate abroad, officers now have a new cable telling them to dig deeper into serious or chronic medical conditions, your ability to pay for care over your lifetime, your education skills, English level, and any past use of public assistance. If they decide you're likely to rely on government support at some point, they can deny your green card, even if your I-864 technically meets the poverty guidelines. Real life example, Anna and Peter. Take Anna from the Philippines, married to Peter, a U.S. citizen who's earning about $28,000 a year, just above the poverty guidelines for a household of two. Under the old approach, they could usually get through consular processing as long as Peter met the income requirement and the marriage was real. Under the new 2025 State Department guidance, Anna's consular officer might scrutinize whether Anna has a chronic health condition, how much savings they actually have, whether they have private health insurance, and whether Anna speaks English or has marketable job skills. Even though their income clears the poverty line on paper, the officer still decides Anna is likely to become a public charge and can deny the visa, especially if they had limited savings and medical risks. If you're worried about waivers tightening or the wealth test getting tougher, here's what you can do now. Do not wait blindly, but don't file blindly either. If you're likely eligible, waiting years to start can be dangerous in a fast-changing system, but rushing a weak case to beat a possible rule can also backfire. Straighten your financial picture. Gather pay stubs, tax returns, employer letters, for your U.S. citizen spouse. Get proof of savings, retirement accounts, property, and any other assets. Show evidence of private health insurance or ability to pay for care. Document your education, your training, and your English skills. Prepare a serious hardship package if you need a waiver. For I-601 or I-601A cases, you want detailed evidence of how your U.S. citizen spouse would suffer if you're forced to leave: medical, emotional, financial, and more. Work with a qualified immigration lawyer. With DHS rulemaking underway and consular guidance shifting, just filling out the forms isn't enough. You need a strategy tailored to your processing location, immigration history, and financial situation. This is the real heart of the issue. If waivers are narrowed and public charge rules get tougher, more families will face spouses stuck outside the United States after consular denials, along multi-year waits with no guarantee of approval, and higher chances of removal proceedings if something goes wrong. I see families like yours all the time. Good people trying to fix their status the right way while the rules move under the feet. That's why it's so important to build the strongest possible case while you still have options. A few dangerous misconceptions for late 2025. If I'm married to a U.S. citizen, I can't be denied. Not true. You can still be denied for unlawful presence bars, misrepresentation, or public charge concerns, especially under stricter consular guidance. I'll just wait until the next president fixes it. Maybe, but if a tougher rule goes into effect while you wait, you might lose options you have today. The laws don't always grandfather in people who have never filed. Public benefits don't matter at all. Under the current DHS rule, most non-cash benefits don't count directly, but certain cash programs and long-term government-funded care do. And consular officers abroad are now told to look broadly at health conditions and overall financial strain. Don't rely on rumors or old advice. The wrong move can cost you years of separation. Here's what I'm watching. DHS's new public charge rule is already at the Office of Management and Budget. Once published, there will be a public announcement period. Then DHS can finalize it, likely sometime in 2026. That rule can make adjustment of status cases much more like the 2019 wealth tests. We'll also see how consulates apply the new health and wealth cable. Officers have a lot of discretion, and over the next year, we'll see how aggressively different posts use it to deny marriage-based visas. To sum up, waivers for marriage-based green cards still exist in late 2025, but they are slower, under more scrutiny, and in the political crosshairs. The public charge wealth test is already tougher for people applying abroad, and DHS has started the process that could bring a stricter version back for green cards inside the United States in 2026. If you're married to a U.S. citizen or a lawful permanent resident and you have immigration issues or limited income, you are in a higher risk category, but you still have options if you act thoughtfully and get the right help. Don't leave your future to rumors on the news or wishful thinking. For even more crucial updates, check out my video, Immigration Cases Are Speeding Up in 2026, But Why? We'll talk about how new rules and court decisions may change processing times and how to protect your family instead of getting blindsided. This isn't just informational, it's about your rights, your future, and what you can do next. See you there.